We'll now enter the period of our hearing where each member has 5 minutes to ask questions, and I will begin by recognizing myself for 5 minutes. Dr. Phillips, thank you for traveling here from Memphis and away from the land of the best barbecue in the world to join us today. You've spoken about how some of Tennessee's laws, such as the 48-hour waiting period, make it difficult for women to obtain an abortion, particularly those who have to travel long distances for multiple visits. You've also spoken about how your hospital is bowed to political pressure and placed severe limits on access to abortion. What are those limits, and how have they affected patients in your care?
Thank you. The hospital that I practice in has relatively arbitrarily limited abortion to the case of rape, incest, and save the life of the mother. The issue is that the medical indication of saving the life of the mother is one that requires a great number of events to happen to actually prove and to document more than just prove. So we have delays. Cases have to be referred to the administration to consider. Many times there requires a number of medical opinions to be documented, and in the meantime, the pregnancy is advancing and advancing. And even though first and second trimester abortions are safe, certainly safer than having a baby, and certainly under these medical circumstances, safer than having a baby, the delays are heart-wrenching for the patient and for their families as they wait. This is one of the big issues that we face all the time.
Ms. Dalvin, Dr. Phillips mentioned the 3 exceptions that are generally in the law, rape, incest, or the life of the mother. In your knowledge of laws in the United States, do most states now see those 3 exceptions, except for these new wave of laws that do not consider those exceptions?
You're absolutely right that there are no such exceptions.
Might need to turn your microphone up.
You're absolutely right that many of the new state bans lack exceptions for rape and incest. That's certainly true in this, and the public is outraged. But the public's outraged by the bans themselves as they affect all women. That's why we saw people take to the streets in more than 500 cities and towns around the country in the middle of the week to express how concerned they were about bans like Alabama's and Ohio's and Kentucky's and Georgia's, where we are seeing politicians increasingly step away from this old argument that they were just trying to protect women's health or just trying to ensure that decisions are informed. Now what we're seeing is people just taking this decision entirely out of the hands of women.
It's interesting that, with the exception of Ohio, the states that have been the worst on these laws are the same states that had miscegenation laws, the same states that made it difficult to vote and were suspect states in the Voting Rights Act, and left the country somewhat unpatriotic of them. Professor Murray, you've explained in your testimony that the reasoning in Roe v. Wade was part of a long line of cases recognizing a right to privacy and a right to make one's own personal decisions in certain areas of life, including people's choice who they might want to marry, same sex, et cetera, and the rights of parents to direct the upbringing of their children. If Roe were overturned, in what ways could those other rights be threatened?
Chairman Cohen, you're absolutely right that Roe versus Wade proceeds from a long provenance of cases. It was not conjured out of whole cloth, but rather proceeds from a series of decisions that were enacted in the 1920s. Right, Meyer versus Nebraska, Pierce versus Society of Sisters, all of which held that parents have the right to the upbringing of their children, an upbringing of their choosing. From those protections, we get Griswold versus Connecticut, the right to privacy and the right to use contraception. From there, we have Roe versus Wade, and from there, we have Lawrence versus Texas, the right to engage in consensual adult sexual relationships, and then from there, Obergefell versus Hodges in 2015, which affirms the right to marry a person of the same sex, and of course, as you say, 1967, Loving versus Virginia. All of these are predicated on the same judicial founding, and if Roe falls, all of these other decisions are equally imperiled.
Thank you, Professor Murray. it's scary to think that we could go back to that era and all those things we consider rights and advancements would fall, and we'd be back in the dark ages. Recognize the ranking member for 5 minutes.